working hours beyond the regular working hours, but also below the maximum limits, extra pay shall be made to the employees, not only to the permanent employees, but also to the temporary employees. In China, the overtime working in the working days, on working days, is twice as the salary available in the regular working hours. And on holidays, it's 3 times. But sorry, I cannot find the the rules here. Yeah, perhaps your law will set a higher standard. Yeah, who knows? Next issue, is the minimum wage. I have already mentioned it, and temporary employees should pay the same minimum rate as permanent or regular employees performing similar work in the same location or industry. And the next issue is the workplace safety. Workplace safety. Workplace safety is a fundamental aspect of labor rights for employees, and it encompasses the measures and practices employers must implement to protect the health, safety, and well-being of the workers while they are on the jobs. Actually, the ILO, International Labor Organization, has established at least 4 conventions to regulate the health and safety. And among them, 2 are fundamental conventions. The ILO conventions can be roughly divided into 3 categories. At the top, fundamental conventions. And before last summer, there were 8 fundamental conventions. But in July last year, 2 safety, occupational health and safety conventions has been escalated to be fundamental conventions. So now there are 10 fundamental conventions. And the second category are the priority conventions. The 2 which now are fundamental conventions were priority conventions at that time. Yeah. And so you could see, the importance of the health and safety the ILO has addressed, right? Because it has upgraded the previously priority conventions to be fundamental conventions in the field of health and safety. And because of this, health and safety has become one of the 5 mostly addressed labor aspects by ILO. And the convention with workers' place safety has several aspects. The first aspect is compliance with health and safety regulations. That is to say, the employers should adhere to all relevant occupational health and safety regulations and standards established by local, national, and international authorities. Yeah, so you could see the rules are, promulgated at various levels. As a matter of fact, not only in the health and safety field, but in the whole labor and social security legal field, the laws are very scattered and not as systematic as in other law fields. And also the authorities which are empowered to establish rules are at various levels. So for that, for this regard, I really envy teachers involved in, for example, the criminal law, because the criminal law for criminal rules only at least in my country, only the central, the national legislatures are empowered to make rules. And the rulemaking power has not been decentralized because penal rules, criminal rules are rules, limiting the people's freedom, and also, for example, the death penalty. Yeah. So, but in the field of labor law and the social security law, the laws are updated very much often. Talking about law here, I do not use a narrow sense. I use a general sense. It consists of both the national laws as well as the local regulations. For example, in my country, provincial governments, provincial congresses, municipal governments, municipal congresses are all empowered to make rules regarding the labor and the social security. So every time when every year I teach the labor law for already 6 years. Yeah, but every time I prepare for the for class, the first thing that I shall do is to check out whether there are updates in the laws and regulations. Yeah, not as teachers in the penal law, for example. Yeah, so the first aspect comes as complies with health and safety regulations. That is to say, the employers shall adhere to the rules established by at various levels. And this obligation to compliance, is also dynamic. That means not to the static rules, but shall to adhere to the dynamic rules, which are constantly updated. And the regulations mentioned here often outline specific requirements for workplace safety, such as maintaining safe working conditions, providing safety equipment, and conducting regular safety inspections. A second aspect of workplace safety is risk assessment. And this principle or this mechanism was firstly invented actually in the Scandinavia law. And then it was, introduced to ILO. ILO has promoted worldwide since that time on. And this mechanism is in line with the principle that eliminating the occupational risks at source. And in context of this mechanism, employers should conduct thorough risk assessments to identify potential hazards in the workplace. This includes evaluating physical, chemical, biological, and psychological risks that temporary employees may face. But here, I do have mentioned psychological risks, but that's highly depending on the laws of jurisdictions, because some jurisdictions do not recognize psychological risks as part of the occupational hazards. Yeah. The countries which recognize psychological risks, namely mental health as part of occupational health, include, for example, the Netherlands, Sweden, Denmark, mostly in Northern Europe. Yeah. And next, aspect of workplace safety is safety training. That is to say, temporary employees should receive comprehensive safety training before starting their jobs. And this training should cover topics such as emergency procedures, proper equipment usage, hazardous materials handling, and general safety practices. Next aspect is health and wellness programs. Some employers offer health and wellness programs that promote the overall well-being of employees, including temporary workers. These programs may include, for example, stress management, mental health support, and wellness initiatives. That is workplace safety. Because of limited time, I do not go too far in discussing it. And next one is the discrimination and harassment, which are significant workplace issues that can have serious consequences for employees and employers. Respecting labor rights, including ensuring that all workers, including temporary employees, are protected from discrimination and harassment in the workplace. Discrimination, as I mentioned at the beginning, that it could be firstly from the employer. This is concerned with unfair treatment, wage discrimination, unequal overtime pay, unequal overtime working, which we have already discussed just now, so I'm not going to repeat them. Discrimination could be also from permanent employees. For example, exclusion and isolation. Permanent employees may exclude temporary workers from workplace activities, social gatherings, meetings, or team building events, leading to feelings of isolation and exclusion. And for the discrimination from the employer, I do have found an example actually in my university, because my university, for a portion of the supporting staff are temporary jobs. And in China, we have three main festivals: the New Year Festival, the Dragon Boat Festival, and the Moon Festival. And for the three festivals, the university is giving employees gifts. But as far as I know, the temporary employees would not give gifts during the festivals. So that is definitely a violation of equal treatment, as mentioned just now from the employer. Yeah, discrimination from the employer. Harassment. Temporary employees can be subjected to various forms of harassment, including, for example, sexual harassment, which includes unwanted advances, commands, or behaviors of a social nature, bullying, repeated mistreatment, humiliation, or intimidation. And also racial or ethnic harassment, for example, offensive commands, jokes, or actions based on race or ethnicity, or aged harassment, religious harassment, and disability-based harassment. Until this moment, China does not recognize occupational health as part of the occupational, does not recognize mental health as part of occupational health. And so in our system, we provide protections against the harassment, actually not throughout the occupational health system at workplace, but instead we use the personality protection system established in the civil law to provide protections against the harassment. And the difference is that in context, if it is recognized by as part of the occupational health, then the burden of proof would be left to the employers because of the strict liability principle existing in the occupational and health law system. If not, then the burden of proof would be left to the employee, yeah, because of the civil law principle over the burden of proof. That's a difference. Yeah. Well, the last general aspect is paid leave. And paid leave refers to time off from work for which employees can continue to receive their regular pay or wages. Paid leave is an essential component of labor rights and employment benefits, and is typically provided for various purposes. And paid leave, are provided in several forms, including, for example, paid vacation leave. When I was, I got my PhD from Utrecht University. When I was in the Netherlands, one of the culture shock, I experienced several culture shocks, but one of them was to see that in summer, Dutch highways are very busy because people driving cars to the south with boats, following them behind their cars. Why? Op vakantie. Yeah, on vacation. Yeah, they are going on vacation to the seasides, to the coastal areas. And why can they do that? Because, perhaps from the Dutch perspective, it's not a satisfied one, but from my perspective, the Netherlands has established a very good paid vacation leave system in their laws. So employees, both the permanent employees and the temporary employees, are granted paid vacation leave. Yeah. And a second form of paid leave is paid sick leave. Paid sick leave is provided to employees who are ill, injured, or require medical care. And third important paid leave is the parental leave, which provides paid time off to employees which become parents, whether through childbirth, adoption, or fostering. And China has been paying attention to addressing paid parental leave because, since last year on, we are not the country which has the largest population in the world anymore, right? India has the largest population. Yeah, indeed, indeed, and Chinese government is in anxiety, because the population is shrinking at this moment slowly, but you cannot know whether it will be accelerating or not. So policies have been introduced to encourage people to have more children. And one of the measures, very much different from like 10 years, a decade ago, very much different now. One of the measures is to provide a sound and working paid parental leave. And I was also invited, to be part of the draft committee to draft a local regulation regulating paid leave, paid parental leave in my location. And that draft will be finished before next February. Yeah. And so paid leave includes, among other things, these three major forms. And, well, next, the strategies, because the issues I mentioned above for temporary employees, their labor rights are usually violated. So my first strategy is to strengthen labor rules. It has two aspects. Firstly, the legislations. Secondly, the implementations. That is to say, if the laws fail to incorporate all the rights that should be enjoyed by temporary employees, as mentioned above, then the laws should be reformed to make a sufficient, comprehensive labor law system. And if it is a problem of implementation, we have the problem at this moment because we have established rules in place, for example, the working hour limits. But our tradition, Chinese tradition, together with other Oriental tradition, for example, Korea, Japan, all address hard working very much, even to a, well, unnecessary extent. So that, negative aspect of the tradition has presented negative impact on the implementation of the working hour limits. And a result is that you find very much often, particularly in the tech sector, overtime working is prevalent. Yeah. For example, we have a so-called 996 working hour system, promoted very much by big tech companies, including Alibaba, including Tencent, for example. The 996 stands for that starting work at 9 o'clock in the morning and get back work at 9 o'clock in the evening, 6 working days per week. That's what 996 stands for. The government is not willing to see that because the government has laws in place which provides 14 working hours per week. And the government is willing to see that the rule is respected in practice. But in practice, the status quo is that long working hours is prevalent, as I said, particularly in the tech sector. Yeah? So you could see that that is a result of negative impact of the tradition. Yeah? Particularly in Oriental countries, Japan, Korea, and China, Vietnam, etc. Yeah. Why is that so? Yeah, because the working hour limits are introduced, transplanted from Western countries. In Western countries, they do not have a tradition which addresses working hard too much, right? So definitely they have simple rules in law book. When you transplant that into your domestic law, if the tradition is exerting negative impact, is exerting influence against the working hour limits, then supporting or bolstering rules shall be established at the same time. And also, the supervision has to be strengthened. And it is also the case here for the labor law implementation. Yeah? If the implementation fails, even there are good rules, but not effective in practice, then strengthen the implementation. Otherwise, the law stay in book, not becoming law in action, right? Not becoming law in action. And a second strategy I propose is to establish a legal culture addressing equality. The unequality, you could see that between the permanent positions and temporary positions. Establishing a legal culture that addresses equality in workplace requires a concerted effort from governments, employers, labor organizations, and society as a whole. So it's a cooperation between all the stakeholders, good governance, which is expertise of Professor Arling, good governance. And that is, well, this is particularly important in hierarchical societies, including, for example, my country, including, for example, Indonesia, Korea, Japan, Vietnam, which has a tradition of not respecting equality in our cultures, right? Because we are hierarchical societies. Yeah. For example, the other day, when we were in Bengkulu, the Bengkulu colleagues, had a lot of hospitalities. They buy us batik, and well, asked me whether you could wear it next day doing the presentation. I said, that's okay, no problem. But when I, communicated with my dean, he said, no, that's not possible because dressing in batik, that's not the international standard. And Kai, you are abroad doing presentations. You shall be dressing as with the international way. It's also a way to promote our law school, and your photos, videos could be used for the propaganda purpose. Yeah. So that is, so he wants me to, to be dressing as the international way. Yeah, not a domestic way, not Indonesia domestic way or Chinese domestic way, because we are also not allowed, at least by my dean, to be dressing in Chinese clothing when attending international events. But, well, I have to follow his orders because I have not found sufficient protections against him at workplace, which is related to the next strategy that I'm going to discuss. Why is that so? Because in our society, hierarchical societies, I would say that our dean is the emperor of my law school. And we have rectors at the university, in the university, and my rector, the rector is emperor of my dean, right? So that's typical in hierarchical societies, well, and that means to address equity is much higher in our societies than in, for example, in Western societies, particularly including particularly the Netherlands, which address equality very well, I would say, because I had spent 6 years there. I experienced the equality very much. Not. I mean, only a few countries in the world which have the same equality culture as the Netherlands have, including, for example, Sweden, because Sweden addresses equality also a lot, right? Their society.
Avallonen has this in thesis. He made critical remarks about the equality principle in the Netherlands, I remember.
Perhaps you are not satisfied with it because you want more about equality, right? Yeah, and well, my next strategy that I would like to propose is to provide sufficient protections to temporary employees at enterprise level. At the enterprise level, employers can take specific actions to provide sufficient protections to temporary employees. And these measures aim to ensure temporary workers are treated fairly, enjoy safe working conditions, and have access to the same rights and benefits as permanent employees. So That's all. They are my points, and thank you very much for your attention. Terima kasih.
Thank you very much, Professor Liu. Professor Liu membicarakan terkait dengan proteksi kepada karyawan temporer, karena tentunya di penyelenggara pemilu juga kita memiliki lembaga ad hoc yang mana adalah masih secara temporer juga setelah untuk pemilu ini. Beberapa isu terkait dengan pegawai ad hoc itu salah satunya perlakuan bagaimana harus ada perlakuan yang sama dengan pegawai reguler atau permanen dengan pekerjaan yang sama termasuk gaji, kondisi kerja dan benefits. Kemudian bagaimana penggajian itu seharusnya adalah dengan UMR. Kerja lembur juga harus dibayar, tempat kerja yang aman, adanya pengaturan terkait dengan regulasi keamanan terkait termasuk dengan program kesehatan, serta cuti dengan tanggungan negara, dan harus ada kebijakan terkait dengan diskriminasi dan pelecehan di tempat kerja bagi pekerja temporer. Begitu, saya mohon izin. We will go to the next discussion in which I will open 3 questions probably from the audience. If you have any question, please raise your hands. Bapak Ibu, sekiranya ada pertanyaan atau diskusi yang ingin disampaikan, kami persilahkan untuk mengangkat tangan. Silahkan.
Terima kasih, Mbak Sari ya. Oh Puspa, maaf. Ya. Oh, Mrs. Puspa, Miss Puspa. Thank you, Mrs. Puspa, Miss Puspa, Mr. Rahmat Bagja, Mr. Professor Eding, and Professor Liu. Kai Liu. First of all, I'd like to comment about the good governance, labor law, and election in digital era. I think it is too much for us to discuss about these four major things, right? Good governance, labor law, and election itself, and in digital era. Maybe if our government is good, also labor law is okay and election is okay, right? And then maybe how good governments in digital area, maybe like that, if I am not mistaken. So do you think that in digital area we'd like to govern? I don't think so. Maybe government is more simple. Maybe government is more simplifies. So my question is for Professor Eding. What do we need? Of course, you have observed our Indonesian situation, our Indonesia. So what does it need to make e-voting? Because we spend a lot of cost in our paper election, in our paper election, in our primitive election, maybe if it's not if it's not so satire, right? Yeah, that is my question first. And for Mr. Bagja, do we need peradilan pemilu, Pak? Kayaknya makin lama kita makin gak didengar gitu, Pak. In terms of our relation with KPU gitu ya. makin lama sepertinya kita makin we the more we talk, the more we speak up, and then the less the regulations against ourselves. I mean, the more the regulation against ourselves. Yeah, for instance, how come PKPU it is transformed into like modification, and then you know our Court of Justice, maybe Mahkamah Konstitusi, it is very influenced by the relatives issues like that. Jadi, my question for Mr. Rahmat is, do we need peradilan pemilu like in Brazil or other countries? And then the last one, my questions for Professor Kai Liu. Your country is impressive in terms of how you expand your territory actually, and how you manage your vision 5, 10, or even 15 years for next times. So my question is, for our ad hoc, is actually we are very concerned about our elections. We are very concerned about our jobs. And in Indonesia, because we live in tropical areas, or we are very like to flock to, I mean, our relatives is like to gather. So even we are jobless, actually we are not in a hunger. There's always solutions. For instance, if our relatives died, we have tahlilan. We have first night, and then the third night, and then 7th night, and then 14 nights. Even after we get fired, we still have what is it? Ngapel ya? What is it? We still have go to friends, and then we get a party. We still have it. Yeah. Or if our young generation want to get married, they only have one word, Bismillah ya. It's like that. So they get married, and after that they seek for the jobs. So the issue is in Indonesia is not about is it part or permanent, but the what is it? The discipline, or maybe the management in our issues about ad hoc electors, about in Bawaslu, in my opinion, is about they are executors, they are supervisors, but they also as a Perdin fighters. They are also as PJs partners. The financial report, sir. So I think that is our main problems. Yeah. Yeah, and also the wage is very unpredictable. It is like moon sun seasons. That is so the questions. My question for Dr. Liu is, you know also Indonesia. Thank you very much. You have gone to Bengkulu. I hope you went to Rejang Lebong. Rejang Lebong, Gunung Bongkok. Yeah. Oh yeah, thank you, sir. Thank you. I hope you like it. I hope you enjoy it. Yeah. What kind of efforts do Indonesia needs to make like Baitu, Alibaba? I mean the entities of Google, the antithesis of Facebook, the antithesis of Twitter, and also the antithesis of your TikTok. So what do Indonesia will? Because in digital area, I think is who governed by algorithm, or who enjoy or who become the victim the algorithm. I think that is I mean we want Indonesia known about algorithm. We want to make a platform or maybe startup that can exchange their platform like that. Saya kira itu. I think that's all, sir. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Yeah, thank you very much for your interesting question. Now, first of all, I think your institution is very important. Your Supervision Election Commission is very important because, as I explained you, there is more and more a kind of balance of power. And your institution is playing an important role in the balance of power in the state. So from one side, you have the government, and from the other side, you have the society. So there, and you have, of course, the Constitutional Court, and you have the Parliament. And so your institution on the point of election, supervision on election, is very important in balancing the power. So that is first of all, because when we only would have political parties, it would be terrible. Everything would be politicized, and I think that such an independent commission like the Supervision Commission on Election is really fundamental from a democratic point of view. So for me, that is very clear, and that means, of course, sometimes you have perhaps the feeling we are writing reports and we are making paperwork, and what is the effect of it? Now, the effect is to start a kind of argumentation when things are going wrong. When things are going wrong in relation to the process of election. And for instance, let me say, I can say something about the presidential elections and the discussion between the Constitutional Court and the Parliament. Things are very clear, but I think in that point of view, in that balancing of power, you need a kind of independent commission. And that, in that position, your institution is. So it is, I think, very, very important. It is also very important in the balance of power, but is most important is in the interest of the people. It's in the interest of the society that there is a controlling, let me say, a supervising institutions on the elections, of course, on central level, but also what's happening in the municipality and what's also happening in provincial level. If you would not have such a supervising institution, everything would be done in different ways. So you have other elections in Jakarta than in Surabaya. Everything, it would be chaotic. So I think in that sense, I can imagine that you are sometimes asking, oh, that's a lot of paperwork, and what is the effect? It has effect, and it will influence the discussion. And it's better to have a discussion between the government and the society, in which the Supervision Election Commission is playing an important role in the sense of arguments. It's better to do that in that way than there is a kind of dictatorship of one president who's saying what's happening, and nobody can have an influence in. So you are playing a very important role from a democratic point of view. So be be aware of that important position, and I would say I would give you my full support for that work. And finally, one remark about principles. Principles are important because they give a kind of direction. They give freedom, they give space to the government, but it is clear in the direction. And that is also important. So by creating these principles, or by applying these principles by the election supervision election commission, they also they give direction to the government, and that is, the government needs that, and you are doing that on behalf of the people. So that so therefore a principle approach is much more attractive than just to look to written law. Written law is important, but you will always need these principles because they are steering. That are the steering mechanism in a state when it is done by the election commission in the field of election. When it's done by the parliament, it's in the field of controlling. When it's done by the ministries, it's done in the field of policy. But principles are fundamental values in the state, and they create legitimacy of the government in the broader sense. Yeah, was that a little an answer of your question? Más o menos?
Yes.
Okay. Can I give you?
Jangan pakai Indonesia aja atau pakai bahasa Inggris? Pertanyaan sekarang, apakah dengan adanya peradilan pemilu, it is like you asked about the election, court of election court. I think there is pro and cons about that, and then if we are making the election court, there's one big problem, which part of the in the power of judiciary will place the election court in the general's court, administrative court, or constitutional court. That's a big problem. And also, they also bought the human resources for the judges. We have experience in the industrial relations court. We have the industrial relations court or labor court, and you can see of the application of the labor relations court is not good enough, and then that's a big problem for us to solve the problem of the labor law, of the labor problems. And then, if we are going to make an election code, there is the question of the people participations about the supervised elections. Because if we are not the case in Bawaslu, we have the case for the report from the people is just for, maybe it's just for about this is the example for the example is just 100 cases, 100 report, but the finding of the election supervisor, the finding of our job is 300% more than that. It is the question of the participation of the people. If the election court had been built, but there is no report for that, what next? That's a big problem. Your job is very important now to make the people aware that if there's not a report to the Bawaslu, the democracy process will be decreasing. That's the cons of the election court. And the human resources, Bawaslu, if the election court, the judges must be Bachelor of Law, Sarjana Hukum. But now in Bawaslu, there is a lot of different background, from the Bachelor of Law, teachers, theology, and this make the principle, our principle, not in the written law, but in the unwritten law, makes broader, I think, because there is people have not just from the law perspective, but also the others studies perspectives. This is our background, that not to make the election court, and also about the financials also. If the election court, that will be the permanent judges, permanent election supervisory, because people awareness not to report. That's the questions. That's a big question for the election courts. Maybe 5 or 10 years more than from now, I think we can talk about the election courts. But now I think it's the Indonesian democratic process is still on the track. It's still on the track because general elections supervised by the election supervisory by the Bawaslu, and the general election general election officer and Bawaslu officer supervise the ethics and conduct by the special committee ethics by the DKPP. This is how the Indonesian election democratic process going. I think you are the part of history of Indonesian's election process now. And then if you want to be a judges, because there is election court 10 years more than now, I think you must prepare for your bachelor degree in law. After the election. Okay.
Well, it's really hard, to look it out your question throughout. Yeah, it's a very much long statement. Well, if I understand you correctly, your question is that how can Indonesia has big tech companies like Baidu, TikTok, Alibaba in China, right? Is that your question? Yeah. Okay. But because I'm not a IT technician, I'm not a businessman, so I can only give you my answer from the legal perspective. But at the same time, I'm doubting you are asking the wrong person, because I'm a labor law expert, and my job, is to promote the labor rights, and which will lead to increasing cost of labors. And if the ideas become reality, I mean the rules that I'm arguing for are written in law, I don't think China has a friendly environment to those big companies, and the companies either are going bankrupt or they are moving out of China. So I'm afraid you are asking the wrong person. But you better ask a commercial law professor or a business law professor. But I can give you, my perspective. Sorry?
You can pass on my question to Jack Ma.
Jack Ma. Sorry, your question, what?
Maybe you can pass on my questions
Oh.
to the
Jack Ma. Okay. if I meet him in China. But I can try to, give you answer as far as I think that there would be answers trying to approach it from a business law perspective, perhaps. Very short answers. Is firstly to establish a legal, a friendly, legal environment to the e-business, to the technologies, and also to establish a legal environment which is friendly to innovation. But I'm really doubting my answers would be working, my suggestions would be working, because I really don't have expertise in that field. Okay.
Thank you so much.
Thank you. Thank you for the opportunity. Allow me to ask you very short question to Prof. Edding. Related to separation of power, because your explanation just now talking about separation of powers on and on, but the basic question is who actually separates the powers? Does the constitution or does the people? That's the questions. Thank you.
Yeah, who is separating the powers? That's, I would say, that is the Constitution. That there you should find it, but of course it depends also on practice. What I said is that the legislative function is more and more done by the administration. So that is not who is deciding. You can say the administration is deciding and taking the more power. That is what's happening in practice. So sometimes it is, no, it could be, let me say, there could be a tension with the Constitution. When you're, for instance, when your constitutional court would say this issue is too far going or too broad in the policy regulation, that is a task of the legislator, then you can say the Constitutional Court is a kind of arbiter in the discussion between the legislator and the executive. So you would expect, and that's also an answer to your question, when the Constitutional Court said this type of regulation is not allowed on ministerial level, but that should be in the law, that should be coming from the legislator, then it is in a sense the Constitutional Court who is deciding about the separation of powers, but in my terms, the balancing of powers. So that would be my answer to you, that from one side you see the practical situation, so the shift of the legislative power to the executive, that is, and also in a certain way from the executive to the judiciary. That is the practical sense. But from a legal perspective, it is the Constitutional Court, in a sense, which is, has the monopoly position in Indonesia on the interpretation of the Constitution. But an interesting question is, and that's also in the case of your discussion at the moment about the presidential election, and the question, how is that with a candidate who is not fulfilling the requirements of the age? Is that according to the Constitution or not? And when you look to the Constitutional Court report, they don't agree. A few are saying, yeah, it's possible. The others are saying, no, that's violation of the Constitution. And there are people who have a dissenting opinion. So sometimes it's also a question of, it depends on your argumentation. Some people some constitutional law specialist will just look into the law, say 40 is the minimum age, 38 is too young, so it's violation of the course. That is one approach. But you can also say, what is the idea behind that article in the Constitution? What was the idea of that age, that minimum age? That would be my approach. So more from a principle point of view. What is the idea behind the when I'm teaching in Utrecht, I'm not teaching my students, say, you have to read in Article 1, 2, and 3 what is written down. No, you have to think, what is the idea of an article? And that would be interesting if lawyers, and then now I'm saying it in the general way, when lawyers would think in terms of principles, in terms of what is the idea behind an article. And when you are doing that, your argumentation is much stronger than just saying it is not according to the law because it's 40 and not 38. So that is what the interesting thing would be if the Constitutional Court would create unwritten principles. That would be interesting. But it is perhaps a step too far, and of course there will be all kinds of political implications. So I am not linked to any political party, so it's easy for me to speak about it. But from a principle point of view, it's an interesting point. And that is not to read only to the article, but also the principle behind the article.
Izin Bapak, apakah cukup? Siap. Bapak Ibu, apakah masih ada pertanyaan atau diskusi yang lain? Silahkan Pak.
Thank you. It's very interesting discussion, Prof. Heng, Pak Rahmat, and Professor Kailiu. I just curious to ask several questions, and my statement also in this night. It's very interesting to follow the development of your theory, Prof. The good digital governance is very nice brand that what is it? Subduing this current situation, and very nice to hear your thought. If like in Saudi Arabia, for instance, one of humanoid robot obtained the legal subject as a citizen, and so many humanoid robot in other countries. And you also teach us about the algorithm supervision. Would it be nice if the right to citizen also can be the right for the EI, because EI also in several court decision, court verdict also recognized as a legal person, for instance. It's very interesting if I hear from your opinion. And Mas Pak Rahmat, I learned from you about your theory concerning electoral justice. Would you like to explain to us, and also Prof. Heng and Professor Kai can hear from your theory? Very interesting, the electoral justice theory. And would be nice if we can develop more about the good electoral governance theory as the new theory that developing by collaborating expert or thinker among Pak Rahmat and Professor Ading, because he already gave me the brain of the good digital governance. and will be good electoral governance. We can develop more about that. And Kai, the labor issues is very complicated, I think, because the expectation of the people is very diverse. But in the digital era, a lot of profession very unique, like a hacker. They think not like employee, but as an investor. If you follow the discourse on, we call it book bounty. So hacker doing research, and if we got a security hole, and then they asking for reward. And they're very rich. They got a lot of money, and they don't want any contract on it. So what do you think about that? So the freelance lover, they call it like that. Okay, that's my question, Kak. Thank you.
Yeah, let's a few words about the right to, let me say, to good administration. I have written, you remember, that article is good administration. Is that a norm for the administration, or is that a fundamental right for the citizens? That's a very interesting question, and asking the question is answering the question, because it is a norm for the administration, but it is also a right to the citizens, and that is perhaps also when we speak about about the election and the governance in relation to the election. You can say, yeah, there is a right for citizens to have good elections, and in that sense, the Supervision Commission is playing an important role to realize that right. And so it is, in a sense, you can say, make a kind of operationalization of one of the fundamental rights. So in that sense, it's a fundamental right, but it is also an obligation for the administration to fulfill that election process. Is that a little what you were asking for, thinking for? Okay, now then I give the microphone to you.
It's a very hard question because electoral justice is not just from me also, and then from the Almarhum Ferry Junaidi and from IDEA. IDEA have principles of the electoral justice, but sometimes in IDEA there is no violation of criminal offense in election law. In Indonesia, we have that. We have the election, criminal election offense. Because in Indonesia, we have 4 different types of violations. It is Indonesian election law have 4 different types of violation. First is the violation of election criminal law, because there is some special criminal article in election law, different with the general's criminal code in Indonesia. Same with the but we have ketinggalan. We have the old general code, Wetboek van Strafrecht. You have that, but we was the old one, the 1918 version, and then now is a difference because we have the new code, but the elections offense is ruled by the election law, not in the code. This is the first type of the violation. The second type is the administrative violations. The administrative violation is if the general elections have a violation, have filed the principles and also the law of administrative, we can process that general elections officers. and general election decisions. And our decisions can be appealed in the administrative court just one times in the election law. But different in, we have two law in election. First, the elections law, and then the second is the local election law. We have the provincials, the governor elections and the mayor elections that different with the election law. And also, if we have decision in local election law, Bawaslu have decisions, have decision, that decision will be appealed in the Bawaslu decision will be appealed in the higher administrative court, different with the election law. This is the different type. And then this is how the problem of elections law in Indonesia, because two election with the different type of enforcement. Okay. And then the third type is the violation of ethics. The violation of ethics is just for the election officer, not the people. And then the fourth type is the violation of the others law. The others law is the neutrality of civil servants, the neutrality of the police officer, neutrality of the armed forces. We have the history that armed forces have great influence to our democracy process. And then because of that, we have the law of the neutrality of the armed forces and the police officers. There's four types. And then there is one power of Bawaslu. Bawaslu is settle the dispute resolutions among the people, among the political party with the general elections. If the general election have a decision, make the political party not satisfied, the political party will be appealed to, challenge that to Bawaslu. And Bawaslu have two types of process. First is the mediation. If the political party and also the general election have a common interest and then have same perspective, that will be the verdict of mediations that conclude the problem. But there is not certified where they will join to the adjudication process. This is how Bawaslu make the electoral justice system. I think you said that this is like quasi-judicials. The Bawaslu is the quasi-judicial system in Bawaslu. Because of that, you said that we have like slightly like election court, slightly, no, not permanently. But I think that it is not the question of the organizer, but the question of the power. The power is like slightly, we have the power of that. And then the academicians and also the election supervisory, pemantaus like the NGO criticize Bawaslu because Bawaslu have the find the problem and also solve the problem and give the sentence to the general elections in the one organization, This is the question of conflict of interest, because we have finding the problem and process the problem and also verdict the problem, make a decision of the problems, and to say that general election you are guilty, you are violation the administrative process. This is the conflict of interest. This is about the Constitutional Court also, the conflict of interest, the question of that. I think now Indonesia have the step forward that we have the mechanism of electoral justice more than the other Asian countries. because if we are benchmarked to Malaysia, compared to Malaysia, the government cannot enforce the law of the. You see the lot of baliho or flyers in this road about the political party. In Malaysia, they can take down the posters, but in Indonesia, Bawaslu have power to enforce the law, and with the also we have proceed the criminal offense with the police and also with the general prosecutor also, and then in the administrative process we have full power to state that generation have violated the administrative law in election law. Then also we have making a power also to resolve the dispute among the political party and the general elections. This is how the electoral justice in Indonesia process. And I think if we learn from this, maybe in the United States there is just one general electoral management body, just one general election. There is no supervisory, there is no code of conduct. But in Indonesia we have 3 different organizations. This is how the electoral justice proceed in Indonesia. But I think now we must step forward to making our decisions more complex, more interpretative, yeah. Because if just we have like just said that this is filed the Article 1, Article 2, there is no no principle that become a memory of the article. That will just like tukang. Tukang is like just like engineer. One by one is plus 2. Yes, there is no. Yes, the law is not working on that way. I think a lot of bachelor of law become the engineers of law. We have the decision about 3 different types of tujuan hukum. Tujuan hukum is like goals of the law, certainty of law, and then beneficiary of the law, and then the justice. We conclude that with the principles, not just by the articles. This is, I think, we have that decision in CIPOL, at the Ceylon also, and then now we must developing the articles, and also we compare with the principle of the law, principle of the good governance, because the basis of violation of international law is the basis is we must look to the principle of the good governance, the concept of good governance. We have 13 principles in Indonesia, but it's a long time ago. 13 principles. Asas semua pemerintahan yang baik. You have done that.
It's law in progress.
Yes, law in progress, but the law is in progress. I think that's our election process, which conclude with the electoral justice system in Indonesia.
You also asked me a question which I do not expertise, I would say. A question about hacker. Well, I'm not of the technological background, so I'm trying to give answers from a labor law perspective, but at the same time I realize that hackers stay anonymous, right? So how to promote their labor rights, how to provide protections vis-a-vis their labor rights, because the employers do not know who they are. How can they pay for their, pension, social security costs? How can their equal pay to be ensured? How can, well, because they also working at home, hackers, and how to ensure that they do not work overtime? That's impossible. So, well, I think this has relevance, well, with cybercrime law, right? Cybercrime law and taxation law, because they become rich. I don't think they pay taxes, according to the law, right? Yeah, so that come with the cyber crime law and tax law. And also, I guess there are kind of money laundering, arising from their activities. Yeah. So my suggestion, which cannot be very much comprehensive because I don't have expertise in that field, but I try to, give you my answer, is to, establish a sound legal framework against, for example, the money laundering. Because especially for the emerging emerging market countries, money laundering is not a long-existing problem. So that means the legal framework might be not competent, to deal with that problem. Yeah. It is also one of the problems in my country, frankly speaking. Money laundering, because China has, the economic development very fast, but rules against this activity has not been comprehensively established. So that is a problem. And also regulation, legal rules against cybercrime. But I mean, that's not a problem only for the emerging markets, but also for developed countries, because of the faster development of the cyber itself. Yeah. So the faster development rules whether they are sufficient, competent to deal with that problem. Yeah. And I suppose a more scientific model of rule generating system can be suggested, that because in context of the traditional model, which is command and control, that means the government is responsible for rulemaking, implementation, enforcement. And so now, but because cybercrime is by nature of technological nature, so it is better to invite all the stakeholders to be involved in the rulemaking, in the implementation, and even in the enforcement, which is called self-regulation, and also or meta-regulation approach. Yeah. Because of that, also, as Professor Arling mentioned, talked a lot about good governance, to invite all the stakeholders. Yeah, good governance again. Yeah, so the rules can be formulated on a more scientific base, more competent to deal with the cyber crimes. And also what important is that because stakeholders, some of them from the industries, some of them not, for example, the consumers. Stakeholders from the industries, they have expertise in technology itself, and they have also clear visions over how their technology could be developing into to some extent. Yeah, not comprehensively, but to some extent. Though the rules formulated in this way could have the potential capacity, to deal with problems in the future. Yeah, that I call ability to imagination. Yeah, it is not only to the technological experts, but also important to the rule makers, right? So that's basically my answer. Hope you satisfied with.
Thank you very much. Mr. and madams, because it is now very late, I think it is best for us to conclude this meeting. Before we close this event, Mr. Bagja, sir, would you like to say closing remarks? Thank you. Thank you very much, Professor Ading. Please give him applause. Mr. Rahmat Bagja, Professor Liu, thank you very much once again for your time. And this has been a very insightful discussion. Saya mohon maaf atas keterbatasan pemahaman dan terjemahan. I apologize for the mistakes that has been made. With the power Mr. Bagja gave me, I am hereby conclude our meeting today. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Mr.
Yes, it was nice.
Very nice.
Discussion.
Yes. Never know also.
Very much.
Yeah, thank you very much.
Excuse me, sir, would you, is it okay if we take a picture together with the audience, please? Bapak Ibu, sekiranya bisa kita berfoto bersama terlebih dahulu untuk menutup acara hari ini.
Menjaga